Jerry? My time. Is Jerry here? Oh,
He took his baseball and went home.
he thinks I'm a phantom.
You get 5 minutes this time.
Oh, come on, really? I don't know if I can get through it that fast.
Get organized.
All right, I am organized. I'm going to read it aloud because the difficulty of writing on safety, abuse, and family court took a lot out of me this week. Following incidents of abuse in 2006 in my marriage, I filed for an order of protection from the courts. I didn't understand what was going on, and I was granted a stipulated order. Within a year, additional incidents took place. This time, after speaking to a police officer, I sought a PFA. My husband, meanwhile, filed for divorce. A full evidentiary hearing took place in criminal court in February of 2007. 3.5 hours of testimony and evidence, including audio evidence my ex-husband introduced of abuse. The abuse involved both of my autistic children and myself, including physical abuse. The criminal court made a finding of abuse and wrote a PFA on behalf of myself and my children. Noticeably absent from the PFA hearing was the guardian ad litem who had been appointed to look out for my children's best interests 6 weeks before. More abuse. 5 months later, while I was in Portland to undergo evaluations of possible abuse and domestic violence, let that sink in for a minute. We have a PFA. I was at the Spurwink Institute. My car exploded, burst into flames. The doors melted shut, but I got out. My car was totaled in minutes. The GAL, who was noticeably absent from the PFA hearing, had recommended to the court and the judge that these evaluations for possible abuse take place. Later, I'd like to address the absurdity of evaluations. I understand that a GAL must perform certain duties to ensure best interests of a child. One of these duties is to see the child with each parent. In the 5 years that the GAL was involved with our family, he did not see the child with each parent. I had to wait in the garage or outdoors when he came to my home. He did not see my son with his father because he said their relationship was strained. A motion was made to the court, therefore, that they should go to reunification therapy. Because the guardian had a plan that we would have shared custody and my son would visit with his father, his abuser, once a week and every other weekend. So reunification therapy was put into place, notwithstanding that Dad lived in Ohio. Every week to Ohio. Final hearing was held in May, and in the judgment, the judge stated the defendant did not abuse the PFA process. What a slippery statement. This presumes that people abuse the PFA process because they have nothing better to do than spend a day in court. It also sort of presumes that a judge granting a PFA after a full evidentiary hearing has no idea what he is doing. In addition, made me very, very unsafe. 5 attempts were made on my life. I'm not really a cat. So, in the fall of 2008, I completed the application and the very extensive interview process to become a member of the Secretary of State's Address Confidentiality Program. I was put into the program, which would legally list my residential address, the place I live in, as a post office box in Augusta. Anybody who need to know, with a valid need to know where I was, could write to the Secretary of State at Augusta, and they would make a determination whether that person really, really needed to know where I was. And I can understand this. If I had witnessed a murder and the police department needed to get in touch with me, it would be perfectly fine for them to call up, come over my house, whatever. That's valid. During the fall,
Just for a second.
yes.
Your 5 minutes is up. Is it the pleasure of the audience to extend another 5 minutes?
It gets better.
Because this is the first person speaking who had a car blow up.
Thank you very much. In the fall of 2008 and the winter of 2009, the guardian ad litem, my husband, and his attorney wrote to the Secretary of State on 3 separate occasions, demanding to know where I was living. The Secretary of State refused to tell them. In January, I decided it would be a good idea to extend my PFA that was due to expire to put it in alignment with the address confidentiality program, because all I ever asked for was just don't know where I am. I'm safer that way. My children are safe that way. In early January, I received a notice of hearing. My hearing was to be on January 30th. The next day, I received a notice that this hearing was not happening. That was made an error. There was no hearing for January 30th. On January 16th, the family court judge, without benefit of due process, terminated my existing PFA and vacated it. Transcripts of a later hearing contain his reasoning for his denial of my due process rights. He said, and I quote from a transcript, I concluded that there was no domestic violence involved in this case, perhaps differing from whatever judge heard the protective order, but that was my conclusion. I did notify the Attorney General of this. I was told that they didn't handle such matters and that I should contact the administrator of the courts. I did. Pine Tree Legal, who had represented me in the PFA, contacted the courts. My family matter attorney contacted the courts, and nothing happened. Throughout March and early April, I was informed by the guardian ad litem and the members of my son's therapeutic team. My son's autistic. He had a team consisting of about 8 people. We had people in my home, approximately, I did the math on it, about 2,000 hours a year. We lived in a crowded place of therapists. He informed them that I was going to be going to jail in April for 30 days for failure to disclose my address. On the way to the courthouse, I had my son's case manager calling me, asking what they were going to do with my son. My sentence was stayed under one condition, that I adhere to all stipulations set out by the guardian ad litem for the second round of reunification therapy. If you recall correctly, the reunification therapy between my son and his father, overseen by a court-appointed therapist, was an abysmal failure. So the guardian ad litem, notwithstanding that Dad lived in Ohio and was going to be doing custody twice a week, and had no relationship, a second plan was made. This therapy involved my son meeting with a non-related adult male, who was not a therapist, who was in fact a college dropout, who had been fired by no less than 4 in-home support agencies. The therapy would take place in a vacant parking lot in his car on Sunday afternoon. This therapy was going to be overseen and monitored by an attorney, none other than the guardian ad litem. Now, the court was fully aware that during the first 3 weeks of the reunification therapy between my son and the non-therapist, the crisis services of Biddeford, Maine had been called into my home on 5 occasions within 3 weeks because of how the child was being affected. The court was fully aware that there was no question that my son was being damaged. His developmental pediatrician from Maine Med showed up in court and said, "Stop this." I had very few choices. 30 days in jail Jeffrey Moskowitz. The court was also fully aware that this young man had demonstrated questionable behavior standards and possessed a negative influence over my son, because extensive testimony and evidence of the same had come out during the divorce hearing 1 year before. Nevertheless, I had no choice. I'm not proud of what I did. 30 days in jail to leave my autistic son on his own, along with my father, who is spending his last days in this nightmare. He was being taken care of by hospice. I was the in-home provider. I sent my son for his therapy in the car with the adult male. Several weeks later, I understand that my son disclosed all of the audio and videotapes of his therapy to his counselor at CSI. Child Protective Services was then contacted. Nevertheless, my son developed clinical depression. There's no recourse for what was done to him, because everything that was done to him was in his best interest. That was determined by a judge and an attorney, both of who are protected by judicial immunity. I asked my children, the other night when I was putting this together, how this all affected them. My daughter, ever like her mother, can weigh the good with the bad, said that it helped her to decide to go into her field where she is a mandated reporter, because she knows what it's like to live without mandated reporters protecting children. And when I asked her, what do you think about justice in Maine? She said, what justice in Maine? My son simply says, they took away my child. I think I want to close. I will get to the evaluations later because that's very entertaining. I do think GAL oversight is absolutely necessary. When I asked my GAL on first meeting him, his qualifications for working with a disabled child like my own, and yes, I have a lot of hubris for that because my son grew up in Chicago and New York and New Jersey and had the best of the best. And I wanted to know who was going to be with him. My guardian ad litem told me he was able to do this job because he had raised a daughter. Judicious sense, or even common sense, should be applied by any judge in response to recommendations of a guardian ad litem, especially when the recommendations of a guardian ad litem fly in the face of professional medical people operating within the state. The court has a severe need for its judges to have some kind of working knowledge of ADA Section 504 of the Rehabilitation Act and IDEA, so that the rights of children, especially disabled children, are protected. Judicial immunity for judges and GALs should be curtailed, especially when they are operating without the purview of being a judge or a GAL, when they think they are medical professionals or psychiatrists or clinicians. And any judge or any court officer who denies due process, which was done to me, needs to undergo a legislative fight at the very least. That's a constitutional right of mine, and it was taken. Thanks.